rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CACV 19-0309, MBA Development Partners, LLC versus City of Scottsdale. Council, a couple of preliminary things. Remind you that we are recording the oral argument, so please identify yourselves and your clients at the beginning of your argument. Each of you will have 20 minutes to present your arguments. Counsel for appellant, if you'll watch the clock and reserve as much time as you'd like for rebuttal. If you'll give us a minute after you argue, before we'll wipe down the podium. They may have already told you that, but we'll want to keep that as clean as possible. Also, please keep in mind we've read the briefs and we've discussed the case in conference, so we are familiar, at least generally, with the facts of this case, which can be a bit overwhelming, but we are familiar with that, and so keep that in mind when making your arguments. Counsel for appellant, you may proceed.
Good morning, and may it please the court. My name is John Egbert. I represent MBA Development Partners, LLC. This appeal presents a pure legal issue of what is the proper interpretation of one of the City of Scottsdale's zoning ordinances. The city's zoning administrator interpreted that ordinance to mean that no more than 22 dwelling units or 31 resort units could be built on parcel 6, regardless of the size of parcel 6 at the time that it's to be developed. The record is clear that before the zoning administrator's interpretation here, every time that the city had an opportunity to interpret that ordinance in the context of parcel 6, without exception, it concluded that parcel 6 was not limited to just 22 dwelling units or 31 resort units.
But counsel, do we even look at those historical decisions if we focus only on the plain language of the ordinance?
That's right, Your Honor. If you determine that the language is unambiguous and you don't have to resort to any of the secondary principles of statutory construction, then you look at the language and you apply it. That's the end of the analysis.
And it seems to me that, it appears to me from the briefing that both parties are pressing the argument that it is unambiguous.
It is. We press both arguments, Your Honor. We say that it is unambiguous, that their interpretation is not reasonable. It ignores important provisions of the ordinance and gives no effect to them. But in the alternative, if you find otherwise, then we think that the secondary principles are equally as strong, if not stronger, in terms of finding in favor of the interpretation that not only MBA is presenting, but that the city itself employed over 23 years of history. So I am going to focus my initial comments on the point that Judge Brown brings up in terms of our position is that we don't have to get past the unambiguous language. The language, the interpretation presented by the zoning administrator has so many instances where it is inconsistent with or gives no effect to, fails to harmonize the language of the ordinance, that it's not reasonable. It doesn't create an ambiguity, and therefore there's only one reasonable interpretation, and that, Your Honors, is the end of the analysis. The reason I say that we get to the point of never getting to those secondary positions, those secondary principles, is that the zoning administrator's interpretation focused on one number, the number 22, that comes out of one column in one table that is just part of one of the stipulations in the entirety of the ordinance.
Counsel, how does your reading of the ordinance give effect to every piece of the table, including all the way to the right-hand side? The the number that's in the maximum units column.
Yes, Your Honor, that's because what the table does is it illustrates the formula that is to be applied here. Everything about the table and the stipulation, this is an important point. The city, and especially the zoning administrator, when he issued his decision, he lifted just the language from the table. Did not have the language, the text that accompanies that, that table, ignored it completely. That language, if you look at the entirety of the stipulation, and indeed the entirety of the ordinance, as this court is required to do, then you'll recognize that what is being done here is providing a significant flexibility for future development of these 6 subparcels. And what the table does is say, this is how we're going to figure out how we're going to allocate and distribute those units, those dwelling units. And the gross acres in column 2, everybody recognizes. And in fact, the language, the text that was omitted by the zoning administrator of stipulation 2 says, the specific location of each parcel shall be determined at the time of site plan review. Elsewhere, a couple pages later, the same ordinance says the location and boundaries of each parcel shall be determined at the time of site plan approval for the parcel. What that means, Your Honor, is that these numbers in column 2, they're not written in stone. They're something that you plug in at the time of site plan review. What is the actual size of parcel 6, for example?
Counsel, I'm sorry to interrupt. The location and boundaries language you just referenced, what part of the ordinance is that?
So it's in 2 places, Your Honor. The first quote that I read from was the text of stipulation 2.
Right.
The second one is at just 6 pages later, and I'll give you the reference, it's index of record 56, page 706 of the Bates stamps.
Thank you.
So that language, and especially when you combine it with all the other language, again, as we have to do, gives indication that what you do is you figure out what is the gross acreage, you multiply it by the allowed density. In this case, it's 15 dwelling units per acre. You multiply those 2 things together, and that gives you the number. Now, there's a couple safeguards, guardrails that are put into this ordinance. One is that it can't exceed 424 total, all of those subparcels. And so you can't make parcel 6 huge and take advantage of the 15 dwelling units and have 800 resort rooms. That would be prohibited.
Right. And on that note, what about, how do you, since we're talking about holistically and bringing everything in together, what about the underlying zoning that the city refers to? Is it the 3N or Z 3-94 zoning or whatever type of zoning it is? But the underlying zoning, the city argues that there's a 4,100 square foot minimum or minimum size for each resort unit. How does that play in here, and how do you affect? Because I'm not a mathematician, but I know how many feet roughly are in an acre, and if you do the math there, it doesn't work. If you can't get anywhere near 15 units per acre, if you're having 4,100 square feet.
You're right, Your Honor, and I'm not a mathematician either, but I've worked hard at this over the months, and I think I have a really good answer for you, and that is, you'll note that on column 3 of the table, it does list the zoning, R4-RH, or is that HD? My glasses aren't.
Yes, R does.
So that's the zoning that applies here. What the important point is, and even the zoning administrator acknowledged this during the hearing, we quoted in the transcript, from the transcript, that this ordinance amends certain aspects of that zoning, that underlying zoning. So here, the the city council voted in 1994 to that what it actually works out, the density that works out if you apply those standard limitations, the number of square feet for dwelling unit, number for resort, works out to be 7.5 for dwelling units. 7.5 dwelling units per acre. But you'll notice that what the city council actually approved for parcels 1 and 3 was less than what otherwise would be allowed under the normal zoning provision.
So they violated their own zoning.
They didn't violate it, Your Honor. That's what they get to do as the city council. They enact zoning.
So he just throws the table on, because the table's not what the table purports to be.
No, Your Honor. What they did is say, normally, all these parcels are subject to R4-R. But we're going to amend that for purposes of this resort parcel. We're going to say that these subparcels, we're going to have different density allowed. 2 of them we're going to have be less than the normal, 7 instead of 7.5. The other 4 we're going to allow to go above. So we're making an exception for these. We're changing what the normal zoning would be. And all the other parts of the R4-R zoning requirements are still applicable here. But because they expressly altered it here in the table and in the ordinance, to the extent they altered it, then that's the new rules that apply to this particular parcel, these parcels that are subject to R4-R.
And have the other 5 parcels been modified the same way? So does anybody have an R4 RHD?
All of them do, Your Honor. But with respect to, R4-R addresses numerous aspects of how you develop property. Only one of them is density. And what the city council did was, with respect to density, they modified the otherwise applicable zoning and said, here's what we're going to allow. So what you do is at the time of it's ready to be developed, you figure out what is the gross acreage. And it really helps to look back. I know that in terms of...
Just clarify, is it gross acreage or gross developable acreage?
Well, yeah, that's right, because there's some that could be, you exclude parts of roads that go through it that you can't develop on the roads.
Environmental concerns, whatever, environment, or a wash or whatever.
All of those things have to be taken into account. You have to comply with those, but I don't know exactly what goes in and out, but I don't think there's been any dispute or discussion about that. It's just whatever the gross acreage is. Here there's no dispute that it's 3.1707. There's no other number that in the record for this parcel. So if you apply that number to the density of 15, that's where you come up with the interpretation that was in fact accepted in the prior instances. So I was starting to say that while it may not be something that you have to look at in terms of trying to figure out what did they mean here, if you look back on how the city actually interpreted it previously, prior to the zoning administrator's interpretation in this case, what they did was in fact figure out what is the gross acreage. And in 2007, it was approximately 2.5. So they multiplied 2.5 times 15, and they came up, and that's how they figured out that 37. There could be 37 dwelling units.
Council, when were the other occasions that you referenced them in your briefs, but 2007, the city approved a plan of 37 units. When was the other?
There's 2 others, Your Honor. In 1995, the year after this ordinance was enacted, they approved 35 resort units. Not 31 that the zoning administrator says.
Based on 2.5 acres?
That one the record isn't clear. I can't follow it for you, but in 2000.
But there's no indication that the number 3.17 ever came out. It came out in 2017, correct?
Yes, Your Honor, that's correct.
Okay.
Because, see, what happens is that there's slight modification. As things actually get developed, then it could be that, okay, we're going to use this much for parcel 5, And so there's slight variations.
But where did the 37 and 35 come from? To what extent are those even valuable if we can't track and see how those were determined?
Well, you can, Your Honor, because in 2007, the city staff expressly said that, quote, approximately, that this parcel consists of, quote, approximately 2.5 acres. So they noted that, and when you multiply 2.5 times 15, which is the allowed density, that's how you get to 37. That gets
But
you
I
to
thought that was
37.
non-resort units. You're talking, they got not, for resort units, I thought you should be higher.
Yeah, these are dwelling units. So in 2007, they said you get 37, you can have up to 37 dwelling units.
Dwelling units.
So it's even higher than that. In fact, if you multiply it by the right ratio, you get to 53 dwelling units. And so the third instance, Your Honor, was this case. In 2016, when MBA purchases the property and then makes its application for its development, it wants to do 62 resort rooms. And so it makes its application, and the first response from the city, the first comment review, which we've cite to and quote from in our briefing, says, okay, historically, 37 dwelling units were allowed here. So please explain to us how you get from 37 dwelling units to 62 resort units. And we have that conversation. We engage and we demonstrate how we get there. And it's simple. As being developed this time, it's 3.1707 gross acres. You multiply that by 15, you get a number, and then you convert that number to resort units, and it's well above the 62 that we're looking for. And when the city comes back with its second review comments several months later, there's no issue. There's no concern about whether or not we've exceeded the allowable number of units. Nothing. We're moving on. And in fact, it moves on until we're right before the Development Review Board hearing's going to be set. And that's when the organized campaign in opposition occurs. And all of a sudden, the zoning administrator shifts and issues an entirely different ruling that contradicts everything that went on before. I only have 3 minutes left, and I would like to reserve some for my rebuttal.
Thank you, counsel.
Good morning, Your Honors. If you permit me to, I'd like to kind of just have this table out for you to look at while
Sure.
we're discussing it.
That's fine.
Good morning. May it please the Court. I'd like to begin by focusing on 3 points to demonstrate why MBA's position in this case doesn't reflect a reasonable interpretation of the ordinance. These points relate first to the function and interpretation of the table in stipulation number 2, the gross acreage of parcel 6, and finally the previous staff interpretations of the ordinance. The table itself is not ambiguous when read in conjunction with the text of the ordinance. The ordinance provides for the development of 55 acres. The basis for MBA's challenge relates to a factual error in the table regarding the size of subparcel 6 and how that error affects the interpretation of the ordinance, if at all. So where in the table indicates that the size of subparcel 6 is 1.49 gross acres, we know that's not true. So the question then becomes, how to account for interpreting the ordinance given that factual error? MBA's solution is for this court to find as a matter of law that the city must first change the gross acreage in the table, multiply by a density of 15 to reach a new maximum in the column 7, and then yet multiply that number again by 1.43 to tell them how many resort units that they
What
can.
is the gross acreage on parcel 6?
So the record actually, before the appeal, where the 3.17 first came into play, the record has two numbers, 2.35 acres and 2.56 acres.
Do you know which it is or not?
It's not clear in the record. The Developers Council references a survey in a letter that he wrote to the city saying that it was 2.35 acres, whereas the 1994 conceptual site plan recognizes it at 2.56 acres.
The 3.17 was not presented to the board, or was presented to the board?
It was presented to the Board of
Right.
Adjustment. It
Okay.
wasn't presented to the zoning administrator or the city staff during the application process.
Okay.
So MBA is arguing essentially that it's all about gross acreage and density, and that this table is mere, it's a formula. And that the column 7, where it says maximum number of units, actually refers to dwelling units. Both of those assertions are not supported by the table or the record or the ordinance.
Because
So first, all you have to do to determine that the table doesn't set forth a mathematical formula is to do the math. So if you look at parcel 1, the gross acreage is 14.68 acres, and the density is 7. But when you multiply those two numbers, you get 102, a little over 102 units. But the table only allocates 100 units to parcel 1. Why is that? Because there was a 424 maximum for development of resort and dwelling over the whole 52 acres. So there were limits put on each subparcel by necessity. If you multiply 3.42, which is in parcel 5, by 10, you get 34.2, but the table only allocates 31 units to parcel 5.
The math is close, but it's not exact.
That's correct. And if it was exact, you would be over the 424 maximum.
And to exceed those figures in the right-hand column, all the way to the right, those maximum units, the only way to exceed those would be a redistribution, say to take some units from one parcel and allocate them to a different parcel. Is that correct?
Correct. And the text of the stipulation number 2, which is at, I believe, Bates number 700 in the record, has a method for you to do that. You can redistribute the units through a staff approval, which actually Mr. Hatter, MBA's expert, did in 1995 in order to achieve the 35 units on parcel 6. The notes, and I believe Mr. Hatter's notes are actually set forth in our brief, indicate that there is a inter-project transfer of 13 units to parcel 6.
That was in the 1995.
95.
Okay.
So he added 13 units to the 22 maximum to achieve the 35 units in 95, but that was based on an inter-project density transfer, which is set forth in the table, and it allows staff flexibility to do that.
so there's a fixed number of units, and they shift between parcels, right?
They can, yes.
So no one ever really knows how many parcels they have available until all of the parcels are worked out to the finite degree.
Fully developed.
Yeah, there you go.
That is not really the view that I would take, because the developer at the time owned the 55 acres, and he set forth this table allocating a number of units.
When did he do that?
Excuse me?
When did he do that? Give me a approximate year.
1993 and 94, when this whole 52-acre piece was in the process of being rezoned.
26 years ago.
Correct. And in the 26 years, parcels 1 through 5 have developed, and none with more than the maximum set forth in.
So let me ask you, is it even possible to do a redistribution? Is it legally possible to still do a redistribution of units? Because my understanding, there are some extra still out there.
You're right.
On paper, at least.
The parcels haven't developed to the maximum of either 385 or 424 mixed.
So could, in theory at least, a redistribution still occur?
So that's an interesting question, and I don't know the answer because that's not the approach MBA has taken. It hasn't asked the city
They
to
have not
redistribute.
made that request to the city,
That's not
to
the
this point.
Excuse me, you're correct, yes.
Okay.
Are parcels 1 through 5 fully developed?
They are developed according to their own development
We
plans.
don't have future plans for development.
There is one parcel, I believe it's parcel 2, that has gotten approval for 4 more units, but those weren't built, and I'm not quite sure what the status of those 4 units are.
So if 1 through 5 are built out, and you know what the total number of developable units in the entire project is, why are we here? Why don't you know exactly what's left after the total number of units, having been developed, leaves you with a number in regard to 6?
It does, and that number is, I think, right around 83 units if there's going to be resort and you want to reach that maximum. But really, MBA is not arguing that you could put 83 units on this parcel. And you have to, the zoning ordinance provides the staff with flexibility to provide for the orderly development of this.
In fact, didn't the original zoning ordinance say that there needed to be at least 90 resort units built?
I don't think that interpretation is supported by the text of the stipulation number 2, because it specifically allows for development
It's
of.
just, it allows that many. You're not saying that it's not a requirement then?
I think like the way the ordinance reads, and it's a little weird, quite frankly, is that you can have
It's probably an
300
understatement of.
you can have 385 dwelling units. But if you're going to put 90 resort units, if you're going to go to 424, you have to have 90 resort units, which makes your residential units 343 or something. So the ordinance itself supports that the entire 52 acres could be dwelling units with no resort at all.
But that's entirely calculable. It's subject to calculation. It's not a, gee, let's
Yes.
just toss it out there and see if it works.
So the maximums, I think I understand your question, Your Honor.
I think this is a case of, how many eggs are in the bag or in the bowl, right? And as you take them out, you know how many are left because you know how many you put in.
So the zoning allows a maximum number of 424 units mixed. But no one is ever going to require property to develop to its maximum potential.
But they're asking to do that.
MBA is asking for 62 units on a parcel that's 2.6 acres, which far exceeds the density. And so the discretion of the city staff interpreting the ordinance allows them that discretion to say no. And quite frankly, when the surrounding community asked the zoning administrator to interpret the ordinance, it was the first interpretation of the ordinance with regard to what could be built on parcel 6.
What was left? In regard to what was left? What could possibly be done? How many eggs can you get back in the box, right?
So the zoning administrator didn't make that determination. He determined how many units could be put on parcel 6.
Okay.
And that's the determination that's before this court.
Counsel, given this whole ordinance, the things that opposing counsel mentioned, that what's been said in the briefing regarding, this conflicts with this seems hard to, let me just cut to the chase here. It seems impossible to harmonize everything that we're being told. So doesn't that render this, as a matter of law, ambiguous? And we need to go to secondary construction. How do we stay in the unambiguous category when we have an error right from right out of the starting gate, multiple errors with regard to acreage, kind of throws us in that loop. How are we supposed to divine legislative intent on that? Then we get into, how redistribution was supposed to work and how, stipulation 12 was supposed to work and stipulation 1 and then 2 thrown in that. Is this truly an unambiguous ordinance, and if so, how?
So the ordinance on its face, there is an argument that it's unambiguous because it gives the staff discretion to interpret it and the flexibility to do so. And importantly, the first stipulation,
Can you stop for a second? Help me understand. That's an important point of view. What gives the staff discretion to interpret this ordinance?
The language of the ordinance. So
okay, go ahead.
if you look at the second sentence of the first stipulation, which I believe is on page Bates number 700, the sentence says, any proposed significant change, and again, we're talking in 1994 to the development plan submitted by the developer at that time, as determined by the Planning and Community Development Administrator, shall require approval through a subsequent public hearing. So the zoning administrator in this case essentially determined that a change from 22 on the face of the table to 62, an increase of over about 300% of what was anticipated on Parcel 6 in 1994 was a substantial change that required further public hearing and approval.
So it's not ambiguous, it's just the numbers are all uncertain, and somebody will decide them at a later date.
I don't think the numbers are uncertain, Your Honor. There's the factual
I thought
error.
the zoning administrator had the latitude to make a determination that changed the calculation.
Because the ordinance gave him that discretion.
Okay, so the uncertainty I was talking about was as to the people who are hoping to develop the property, depending on what the zoning administrator says at a later date.
Well, Your Honor, if you're looking at this ordinance, when it was passed in 1994, the entire site was owned by the same developer. And that developer came to the city for the rezoning of this resort parcel. He's the one that submitted this 5 sub-parcels. So, yes, you are looking at the intent of what was going on in 1994 between that developer and the city. Because the interesting thing about this ordinance is it isn't generally applicable to all property in the city, like a lot of ordinances that you would normally deal with. It's just applicable to this 55 acres, or 55, 52 acres. So at that time, this is what the developer anticipated, recognizing there's a factual error, and he put 22 units maximum on parcel 6, regardless of the size.
Did the developer, do you agree with Mr. Egbert's argument that the 4,100 square foot gross land area limitation or minimum for the underlying zoning, that went away when this ordinance was adopted? I mean, that's not what you say in your brief, and so I'm curious to know what you say now. Does that requirement still exist today?
So the amended development standards are in the record. They're actually part of the ordinance. And one of those amended development standards, and I think that's at Bates Label 733 and 734, one of those amended development standards, right after it says that the 4,100 square feet required for the resort, says that council may concentrate regulations of density by a public hearing. That's in the development standards. That's part of the city code. So the zoning administrator explained it to the Board of Adjustment that the council did just that. They did concentrate density in approving this table. So there had earlier been I think there had been some arguments in the record made where it shouldn't have been 15, it should have been 10, but the zoning administrator didn't find that that was the case. He simply found that, based on the table, plain language of the ordinance, that if MBA wanted to build more than the 31 resort rooms that he allocated that they would need a further public hearing.
Council, can I jump in on this? So, if you'd agree, we're not just looking at this table and determining the outcome of this case. We have to review the ordinance as a whole to try to read it as consistently as we can, correct?
Yes,
So we're not just looking at table 2. That's just one part of the ordinance, correct?
that is one part of the ordinance.
So can I don't know if you have stipulation 2 in front of you.
Sure.
And I know the MBA is not arguing redistribution. They're simply saying, we just have to stay within the maximum density. We have to stay below the maximum density is what MBA is saying. But there's a sentence in stipulation 2 that says redistribution of the units is subject to maximum densities and project coordination staff approval. Even though we're not talking about redistribution, doesn't this language give the impression that the city council was concerned about maximum density and then the city approving any changes? They're not so concerned about the number of units in table 2 per parcel. They care about the overall number of units. But doesn't this language help us come to the conclusion that it's the maximum density in table 2 that is the most important? Or am I reading that wrong?
I think that I respectfully disagree with your interpretation that the 424 overall is the important number, because otherwise the developer wouldn't have set out 5 subparcels. I just think that's illogical to assume the developer would have separated these into subparcels if he didn't have some idea that of what he put on the table was realistic for each of the
What about
subparcels.
the maximum density for parcels?
So-
This language.
So maybe an example would help, because I think the real way to explain the maximum densities in that sentence, so stipulation number 2 in the text, is redistribution of the units, which is what Mr. Hatter did in 1995, is subject to maximum densities. So for instance, I think he took 13 units from some other parcel. Now, in 1995, Diamond Land Investments still owned parcels 2, 4, and 5, which had been developed. So he doesn't specifically state it in his notes, but let's assume he took from one of those parcels. So he would have to say he took 13 parcels from parcel 2, and he wanted to add them to say he took 50 units from parcel 2 and wanted to add it to parcel 5 to achieve 61 units. But you have to then go back and look at the gross acreage and the density. You can't exceed the density just because of a redistribution. I'm sorry.
I guess my point is, doesn't this sentence, so long as parcel 6 stays under the maximum density, when you change column 2, gross acreage, the way that the zoning administrator interpreted it in Scottsdale saying is the last column 22 doesn't change regardless. And I'm saying, doesn't this type of language right before the table in the ordinance, doesn't this type of language support the position that the city council was most concerned about the density, not the number of maximum units on the parcels?
I disagree with that only because it gave staff discretion to approve the redistribution. And that's based on more than one thing, based on more than just the density. I see I'm almost out of time, but I really just wanted to point out one more thing. The maximum number of units in column 7 doesn't refer to dwelling units. It's maximum
sorry.
number,
Doesn't necessarily.
doesn't refer to dwelling units
Dwelling, thank you.
in the heading of the column. So that necessarily refers to either resort or dwelling.
Okay,
Thank you.
thank you.
Which, I'm
Oh, go
sorry,
ahead, go ahead.
Which the zoning administrator would disagree with you on, because didn't he say 22 or 31?
I think he recognized that the maximum number in column 7 could refer to either dwelling or resort. MBA wants to build resort. Nobody disputes that they can. So he considered them dwelling units, converted them to 31, in a sense, resolving any ambiguity in favor of allowing MBA to develop more than is listed on the table.
Okay, thank you, counsel. Yeah, hold on a second.
Your Honors, there are several very important points that I need to click through very quickly. First of all, with respect to the acreage of parcel 6 today, there's no dispute in the record that it's 3.17. Council refers to in 1995 there was a number and some other time there was a number, but our point is that, and the language of the stipulation 2 accounts for changes over time, at different times, depending on how the relative subparcels are configured. And so there's no dispute that it's 3.1707. And we attached and we cited to the actual survey. That's the only survey. And by the way, that survey was done in time before the city's third comment review, and it was provided.
So you're saying as long as we know for a fact that it's 3.17, the rest of the calculations are simple?
It's done, Your Honor. There is the
What if
whole
it changes again? It's changed 3 times. I mean, I don't know.
There was an error, but see the point, Your Honor, remember, before that was even enacted by the city, council comes forward and says, hey, there's an error in the stated numbers for 3 of the parcels. And nobody does anything about it. Why is that?
I don't know.
I'll tell you why, because it doesn't matter.
Yeah.
The whole thing contemplates that it's going to be, as it says, the location, the boundaries and location are going to be determined as of the time of site plan review. Later on, 10 years from now, or 26
So
years
parcel
from now.
6 could have changed to 15 acres.
Well, but there's reasonable
I mean,
limitations,
there was a
Your Honor.
conceptual plan, wasn't there? Wasn't there a conceptual plan?
There was an initial one, sure. But the point is, you can't just change it to whatever you want because there's a max of 424 combined resort. Another second very important point to Judge Jones's comments and questions. At the time, we're dealing with hypotheticals back in 1994, trying to figure out, okay, if we take 10 from parcel 1 and give it to parcel 4, what does that do? We've got to get permission from parcel 1 in order to give it to parcel 4 for the redistribution process that's outlined here. In 2016, all of the other 5 are developed. We know what they are. Even if you want to count an additional 4, we're nowhere near maxing out on the 424 limitation. There's no need to go to parcel 1 and say, you're fully developed. Do you mind if we use some of your unused allocation so that we can get to our maximum of 15 dwelling units per acre? It becomes unnecessary at that point. It's not a zero-sum game. We're not taking from anybody. So the only limitation here is to make sure that we're, number 1, not violating the 15 dwelling units per acre, which we're not, and we're not exceeding the 424 combined maximum, which we're not. Council's in response to the question about, so where does the zoning administrator get discretion just to interpret this and change it? Well, not interpret it, but to allocate, make these kinds of changes. Well, it does. She points to nothing. She pointed to stipulation number 1 and read, any proposed significant change as determined by the Planning and Community Development Administrator shall require approval. That's for a significant change. That's not when you put in the formula and you calculate it. That's not a change. That's what was intended from the beginning. There's no change here that needs council approval. Council agreed that as long as you just implement and stay within the guardrails of this formula in this table, you don't need to come back to us. City staff, you have the power, you have the ability to approve that if there's changes in the acreage size and the 22 is not written in stone. That's their case. They've interpreted it that way for the first time in history. One final comment, I'm out. So if you want me to stop, I'll stop. But I did just want to make
Go
30
ahead.
seconds. If we do get to ambiguity, the analysis ends with Cubby. This is a zoning ordinance in derogation of the common law and of property rights. And the cases, including a case that was just decided a couple months ago that we've cited in our supplemental citation of authority, they're consistently say that the ambiguity must be resolved in favor of the property owner. That's MBA here. And so there's nothing that precludes MBA from developing the property based on the erroneous interpretation of the zoning administrator. And we would request respectfully that it be overturned. Thank you.
Council, thank you both for your arguments this morning. It's been very helpful. We will take this matter under advisement, issue a decision in due course. The court is adjourned.